You're going to lose this case, sweetheart. Men like me don't lose to women like you. Tessa Warwick heard those words at 8:47 in the morning, spoken low and flat, directly into her left ear as she arranged her legal briefs on the plaintiff's table. She didn't flinch. She didn't turn around. She simply continued stacking her folders in the precise order she had planned the night before, her movements unhurried, her breathing steady, her face a perfect, impenetrable mask. The man who had whispered those words, senior partner Douglas Crane of Crane, Eldridge and Holt, straightened up behind her and walked casually back to the defense table, adjusting his gold cufflinks as if he had merely commented on the weather. He was 61 years old, silver-haired, and had the particular brand of effortless arrogance that only comes from spending 4 decades winning by intimidation, before a single argument is ever made. He had never once been disbarred, sued, or seriously disciplined, not because he was clean, but because he was protected by a network of favors, golf course handshakes, and campaign donations that ran 3 layers deep through every institution in Mecklenburg County, North Carolina. Tessa didn't need to turn around to know he was smiling. She had been warned, repeatedly. Her supervising attorney at the civil rights non-profit where she worked, a tired but brilliant man named Howard, had sat across from her the evening before and laid it out plainly. "Crane is going to try to get in your head before you even open your mouth," Howard had said, folding his hands on the desk. "He has done it to every young attorney who has ever squared off against him. He whispers things, says things in hallways. He wants you rattled before the jury panel is even seated." Howard had paused and looked at her carefully over the rim of his glasses. "Don't let him rattle you, Tessa." She hadn't been rattled then. She wasn't rattled now. What Tessa felt instead was a cold and clarifying focus that she had spent 11 years cultivating. Not in law school, not in moot court competitions, but in the places Douglas Crane had never been required to go. She had grown up in a cramped 2-bedroom apartment in West Charlotte with her mother and 2 younger brothers, watching her mother work double shifts at the county hospital laundry facility for 19 consecutive years without a single sick day, a single raise, or a single word of recognition. She had watched the system process her family with the particular bureaucratic indifference reserved for people it considered disposable. She had learned, early and permanently, that anger was a fuel that burned out fast. Precision lasted longer. The courtroom in the Mecklenburg County Civil Superior Court building was a large, wood-paneled room with a vaulted ceiling and tall windows that let in pale morning light. The gallery behind the bar was already filling with people. Reporters, law students, community members in their good church clothes who had taken off work to be here. This case had been building for 8 months, and it was, as one local paper had put it, the most significant employment discrimination lawsuit the county had seen in 15 years. The plaintiff was a man named Elwood Sims. Elwood was 63 years old, a former senior civil engineer with Crane's largest client, a regional infrastructure development firm called Meridian Group. He had worked for Meridian for 22 years. He had designed bridges, overpasses, retaining walls, and drainage systems across 6 counties. He had trained half the engineering department. 3 years ago, after raising formal internal complaints about racially discriminatory promotion practices, complaints that were documented, time-stamped and witnessed, he had been quietly restructured out of his position in favor of a 34-year-old with 12 years less experience and a fraction of his credentials. The termination letter had cited departmental restructuring and budget realignment. Not one word about his race, not one word about his complaints. Douglas Crane's firm had been retained to ensure it stayed that way. Elwood sat at the plaintiff's table beside Tessa, wearing a brown suit that his wife had pressed the night before. He was a large man, broad-shouldered, with close-cropped silver hair and reading glasses perched at the end of his nose. His hands, resting on the table, were absolutely still. He had the stillness of a man who had already survived the worst of it and was simply waiting to see if the world would choose to acknowledge what it had done to him. Tessa had met Elwood 8 months ago when his daughter brought him into the non-profit's intake office. She remembered his voice being very quiet when he described what had happened. Not defeated quiet. Contained quiet. He had placed his documentation on the table in a neat stack, internal complaint forms, email threads, a personally notarized account of a meeting where his direct supervisor had told him, in front of 2 witnesses, that leadership was looking for someone who could grow with the company's new direction. Elwood had noted the date, time, and full names of both witnesses before leaving the room. He had been preparing for this for a long time. She had taken the case immediately. Douglas Crane delivered his opening statement the way a man delivers a sermon he has given 100 times. Confident, fluid, calibrated for the back row of the gallery. He spoke warmly about Meridian's commitment to excellence, their record of community investment, and the regrettable but necessary realities of corporate restructuring in a volatile economic climate. He said the word restructuring 9 times. He never once said Elwood's name. He referred to him only as the plaintiff, in a tone that carried, without ever stating, the faint implication that the plaintiff was a nuisance, a minor irritation, a misunderstanding dressed in a lawsuit. Several jurors nodded along. When Tessa stood for the plaintiff's opening statement, she didn't approach the jury box immediately. She stood behind the plaintiff's table for a full 3 seconds of silence. It was a technique Howard had taught her, borrowed from a trial lawyer who had borrowed it from a preacher. Silence, used deliberately, commands more attention than almost any opening word. When the room was fully hers, she walked to a position directly in front of the jury and said, simply, "Elwood Sims built bridges." She let that sit, not metaphorically, literally. He designed load-bearing structures that tens of thousands of people in this county drive over every single day without a second thought, because the engineering is that sound. He gave Meridian Group 22 years. 22 years of his expertise, his precision, his institutional knowledge, and his mentorship of the people who came after him. And when he had the courage to put in writing what he had watched happen to every black engineer above a certain pay grade at Meridian for the last decade, he was gone within 6 months. She paused. The defense will use the word restructuring many times this week. I want you to pay close attention to what was restructured, when, and for whom. 3 jurors who had been nodding at Crane's remarks had stopped nodding. 2 of them were leaning forward. The first 2 days of testimony were careful and methodical. Tessa called Elwood's former colleagues one by one, establishing a pattern that the defense, to its visible discomfort, could not cleanly explain away. A white engineer hired 3 years after Elwood, with significantly less experience, had been promoted twice in the same period. Elwood received a single lateral title change. A black female engineer with a master's degree who had filed an informal complaint about a hostile supervisor had been restructured 4 months later. A senior project manager who had been in the room during the meeting with Elwood's supervisor took the stand and confirmed, clearly and directly, that the phrase "new direction" had been used, and that no budget documents had been presented or referenced in that meeting. Crane's cross-examinations were aggressive and technically competent. He questioned memories, implied selective recollections, and worked hard to reframe every piece of testimony as ambiguous, coincidental, or contaminated by groupthink. He was good at it. He made one witness visibly flustered, and another briefly contradict herself on a minor detail, which he then underlined 3 times as if it were the whole of her testimony. Tessa watched each cross-examination with her pen, moving steadily across her notepad, her expression giving away nothing. On the morning of the 3rd day, Crane filed an emergency motion to exclude a key document, an internal diversity audit Meridian had commissioned in 2019 and promptly buried. The audit contained demographic promotion data broken down by department, by year, and by race. It was, in the language of legal strategy, devastating. Tessa had found it in a discovery batch of over 14,000 documents, buried in a subfolder of a subfolder, with a file name that appeared to be a random string of letters and numbers. It had taken her 4 days of 17-hour document review sessions to find it. She had found it on a Thursday night at 11:42 p.m., and she had sat very still at her kitchen table for about 40 seconds, before she allowed herself to close her eyes and breathe. Crane's motion argued the document was privileged attorney-client communication, and should never have been included in the discovery production. He argued it with the smooth authority of someone who believed the motion was a formality, who believed the judge would simply agree. Judge Constance Abernethy did not simply agree. Judge Abernethy was a 67-year-old woman who had been on the Mecklenburg County Superior Court bench for 18 years. She had iron-gray hair, cut short and practical, reading glasses on a chain around her neck, and the patient, undeceivable expression of someone who had seen every maneuver in the procedural playbook and was no longer impressed by any of them. She read both briefs overnight, convened a chambers hearing the following morning, and emerged with a 12-page ruling that was, as Howard later described it while reading it at his desk, methodical and absolutely merciless. The audit was admissible. Crane accepted the ruling with the practiced composure of a man who had lost motions before. But for the first time that week, when he returned to the defense table, he did not adjust his cufflinks. He sat down and opened a folder with a slightly more deliberate motion than usual. Tessa noticed. The audit itself was introduced through Meridian's own former head of HR, a woman named Carolyn, who had left the company 18 months prior under circumstances she described on the stand as untenable. She confirmed that the audit had been presented to the executive leadership team in a closed meeting in November 2019. She confirmed that the executive team had reviewed the findings, which showed black employees were promoted at roughly 40% of the rate of their white counterparts in engineering roles. She confirmed that the response from the CEO had been, in her words, to ask whether the audit could be reframed around skill differentials rather than demographic data. She confirmed that she had objected. She confirmed that her own position had been eliminated 14 months later. The courtroom was very quiet during Carolyn's testimony. Quiet in the particular way that rooms get when a truth that everyone has been dancing around is finally spoken plainly and out loud, and there is simply nothing left to do but hear it. On cross, Crane attempted to establish that Carolyn had a personal grievance against Meridian and was therefore a biased witness. He spent 20 minutes on it. He established that she had, in fact, filed her own wrongful termination complaint. On redirect, Tessa asked Carolyn one question. In November 2019, when the executive team asked whether the audit findings could be reframed, what happened to the data itself? Carolyn looked at the jury and answered without hesitation. The full report was removed from the company's shared drive. A summary version, without the demographic breakdown, was distributed instead. I kept a personal copy because I didn't feel right about it. Tessa had gotten that copy through a separate channel 4 months into discovery. Crane did not recross. On the fifth and final day of testimony, Elwood Sims took the stand. Tessa had prepared him thoroughly, not in the sense of coaching his answers, but in the sense of helping him understand that he was not required to perform anything. He did not need to be angry or devastated or eloquent. He simply needed to be precise. He was, by nature and by training, a precise man. He answered every question clearly and directly. He described his 22 years at Meridian with a specificity that was almost architecturally detailed. Project names, dollar values, delivery timelines, the names of every junior engineer he had mentored. He described the internal complaint process without embellishment, reading from his own notes, which he had requested permission from the court to keep on the stand. He described the meeting where the phrase "new direction" had been used. He described the 6 months that followed, the way certain conversations had stopped happening around him, the way his name had begun to disappear from email threads, on projects he had built from the ground up. Crane's cross-examination of Elwood lasted just under 90 minutes. He was thorough and relentless, and there were moments when the questioning was pointed enough that the courtroom grew tense. But Elwood answered every question the same way he always answered them, carefully, factually, without heat. He did not become defensive. He did not take the bait on the several occasions Crane floated an implication just beneath the surface of a question, waiting for Elwood to react emotionally so the reaction could become the story. Elwood did not give him a reaction. At one point, Crane asked whether Elwood had ever considered that perhaps his complaint itself, regardless of its merits, had created a working environment that made his continued employment administratively difficult. Elwood looked at him for a moment and said, "I considered that possibility. That's why I documented everything before I filed it." A woman in the gallery laughed quietly and then covered her mouth. Judge Abernethy did not smile, but there was a brief, almost imperceptible pause before she called for order. Closing arguments were delivered on a Friday afternoon. Crane's was polished and long, structured around the theme of ambiguity, reasonable interpretations, alternative explanations, the dangers of reading malicious intent into impersonal corporate decisions. He used a lot of words that meant, essentially, that nothing could be proven, not really, not beyond a reasonable doubt, not to the standard required. Tessa's closing was shorter, She stood in front of the jury and walked them, slowly and in sequence, through the audit, the HR director's testimony, the promotion data, the buried summary, and the pattern across 6 years and 4 employees. She did not ask them to feel angry. She did not invoke anything larger than what was directly in evidence. She simply laid the pieces next to each other, in order, and said, "You don't need to read minds, you just need to read documents." The jury deliberated for 4 hours and 20 minutes. The verdict was for the plaintiff on all counts: compensatory damages, punitive damages. The punitive figure was large enough that it landed in regional news within an hour of the verdict being read. In the hallway outside the courtroom, Elwood stood very still while his wife held his arm. He wasn't crying. He looked the way Tessa had imagined he might look. Not triumphant, exactly, but settled. The way a man looks when a debt that has been owed for a very long time has finally been acknowledged, if not fully repaid. His daughter, who had been sitting in the gallery since day one, embraced Tessa in the hallway without saying anything. Tessa let her. Howard was leaning against the far wall, reading the verdict sheet with his reading glasses on, and when Tessa made eye contact with him across the hall, he gave her a single, slow nod. That was, from Howard, the equivalent of a standing ovation. Reporters gathered. Tessa spoke carefully and briefly, attributing the outcome to the evidence, which was true, and which was also, she understood, the most powerful thing she could say. She did not mention Douglas Crane by name. Crane himself did not speak to the press. He walked out of the building with 2 associates at his heels and got into a black car waiting at the curb. The car pulled away before the reporters finished organizing themselves. Within a week, 3 additional former Meridian employees had contacted the non-profit requesting intake appointments. Howard sent Tessa the email thread with the subject line, "Your inbox is about to get busy." She replied with, "Good." The civil verdict did not end things for Meridian Group. The audit's sudden public existence, combined with the verdict, triggered a formal inquiry by the State Equal Employment Opportunity Office, which had quietly opened a parallel administrative investigation 4 months earlier on the basis of 2 separate complaints from current Meridian employees. That investigation expanded. Meridian's board, evidently alarmed, commissioned an independent review of their HR practices. 3 executives named in Carolyn's testimony were placed on administrative leave within 60 days of the verdict. The CEO, who had asked for the audit to be reframed, announced his retirement in a press release that used the phrase, "spend more time with family," and was met with the particular silence that greeting such announcements tends to attract. Douglas Crane's firm was quietly removed from Meridian's retained counsel list. Word moved through the legal community the way it always does, not loudly, but thoroughly. 2 junior associates at Crane, Eldridge and Holt, contacted the local bar's Young Lawyers Division about transferring to public interest work. None of this, Tessa understood, constituted justice in any complete or sufficient sense. Elwood Sims had lost 3 years of his career during what should have been its most recognized chapter. The settlement, however significant, did not restore that. It did not undo the quiet professional suffocation of the years between his complaint and his exit. It did not account for what it cost him to carry that documentation around, updating it, organizing it, keeping it safe, not knowing whether it would ever matter. What it did was create a record, a documented, adjudicated, public record that said, "This happened, it was deliberate, and it was wrong." Elwood had understood the value of records long before Tessa did. On the Monday after the verdict, she received an envelope in the office mail. Inside was a handwritten note on plain white paper in a careful, structured script that she recognized immediately as the handwriting of an engineer, neat, unhurried, every letter given exactly the space it needed. It said, "Mrs. Warwick, my daughter told me you worked 17-hour days for 8 months on this case. I want you to know that I was aware of every hour, and I did not take a single one for granted." Whatever happens next, this was seen. E. Sims. Tessa read the note twice, placed it in the top drawer of her desk, and went back to work. There were 3 new intake files on her chair, and a 4th one on Howard's desk with a sticky note that said, "Your call." She picked up the first file and opened it.